Out of the dust, we're now rising up and we say, yeah, we're calling you so strong. Our unending source, you provided before. Oh Lord, we're calling you so strong. Say it again. Oh Lord, we're calling you so strong. And if the voice of your people should you say, yeah, it's the harvest. Show us your goodness, so strong. Restore the years that we've sown in tears. And you say it again, say I hear the voice of your people shout. Before time, we sing. The people cry on, we sing. And hear the voice of your people. We sing. And hear the voice of the people. Yes. And hear the voice of your people. Faithful, 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 yeah. Rise up and hear the voice of your people. Hey, hey. And hear the voice of your people. My. Hey, the voice of prayer. I can hear the voice of your people.
Greetings, greetings, greetings. It is I, your King, King Clifford Jefferson, a descendant of Jesus Christ, who we know as King Edgar the Peaceful, the King of Peace, the King of Salem. I'm here today amongst you all with another marvelous lesson today that I'm always as obligated to do. and within my calling. I greet you in the name of King Edgar the Peaceful, which, as I said, is Jesus Christ. I greet you in all the name of the saints, martyrs, etc., who have died and left our historical message throughout what we call time immemorial. It is October 20th, 2023, which is the birth year 2973. I greet you all in the name of love. Welcome to another marvelous lesson. I want to give a special honor to my queen, Sister Galveston, as well as Archbishop Belmont from the House of Belmont, for their marvelous work here in the English Theological Church of England to prepare the way for you and all of you, for all of you. Okay, so let's get started. Today's lesson is going to give you a better understanding about our Constitution. All right, our Constitution and the oath according to that Constitution. We know the Constitution is the supreme law of the land. All right, we know this, the United States Constitution derived their authority from the state's Constitution, i.e. the Confederate States. And this needs to be discussed because a lot of the citizens claim to have rights. You know, rights is fundamental, all right, is inalienable. You know, and a lot of times when we receive due process of law and the particular forums that are set up, you know, we must understand the forum that we go to. And, you know, there's a lot of platforms out there claim to know law, understand law, you know, and law is vague, you know, it's very vague. So I come to clear up law and the origin of law and the purpose of law and the intent of law as it applies to the citizen, i.e. subject, whatever name you want to call it. It's very important that you grasp today's lesson because it's going to depend upon your future salvation. We're in the present now, and you can have no future salvation in the present without understanding the past, okay? And we know that preservation of all rights is the law. Once again, it's the law. Sip of water. Always, I don't say not nervous, but it's very important. You know, I take this very serious when it comes to my people. You know, as we can see, the state that the world is in, so much turmoil, so much pain, so much detrimental things according or contradictory to sustaining human life. And when I look at the platforms on YouTube or TikTok or whatever they may be, all I see is remnants of the wars, remnants of the conflicts between religion, remnants of the parties involved. You know, nothing's really fashioned towards bringing a conclusion to what's going on, not just around the world, but here. You know, we're so focused on what's going on around the world there instead of focus on here, because here is being affected by what's going on around the world. And it all comes down to the body of politics or the government, you know, which are the ones who are infiltrating or influencing what's going on around the world. And it's going to winnow down to here or to whatever area you are in, you know. So it's very important for you to grasp your meaningness to society, not just individually, but as a whole. Okay, so bear with me. I try to move quickly. Okay, we must grasp this understanding as a whole. You know, our earthly salvation depends on it, you know. As you see, I got several podcasts, several lectures on our platform, which will be very vital to you grasping what is going to be said today. And this is just dealing with our physical uh, 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 existence here, but I also gave information dealing with our eternal existence here on this plane, on this earthly plane. So please view the past lectures that I've done. It's very important, and take your time understanding. I know I don't get that many views, but I'm not concerned about the views. My only concern is about you raising your frequency, raising your vibration in regards to your search for a better future. We know future to us as what the world seem today is our immortality, because we see the world is headed for destruction. All right, and we see the death and the mass death that's going on around the world as a result of not understanding our place in society. We're being affected by what's going on in the world because we don't understand our place in society. And if we don't fix that problem, not just what's going on over there in Israel and Gaza, but it's going to start happening here. All right? We must hold our leaders accountable. You have the power, and the power starts at the root. Like we said, we're in the present. We must go back to the root, and the root is the past. Majority of us don't understand our past. The United States is the most powerful nation in the world today, all right? But we don't understand United States past, all right? The United States past plays a big part or a big play in what's going on around the world. A lot of platforms claim to teach this and know the cause of this, but they don't know the cause. They only see an effect and building upon the effect of the cause that they don't know. All right, and that's the problem. So it's my job and my continuous job to be able to break this down and simplify it so you can get a better understanding of the part that you play in this whole big puzzle. All right, very simple to explain. And once again, if you don't watch this video, that's on you. If you don't like it, no thumbs up, that's on you. I don't care if it's being monitored by YouTube monitors or the government. I wouldn't care less. But it's better for you to not notice than to notice and not follow it. So if you are watching it, you're going to be held accountable for the what we call the punishment that results from your not obliging to what is being given to you, because it all comes down to an oath of allegiance. Oath of allegiance to who you declare is to be the sovereign. All right, who is to be the sovereign? Most of the time when we go into our present government, whether it be on the state level, federal level, we're claiming to be the sovereigns. They're claiming to be the sovereigns, but no one can prove who is actually the sovereign. All right. So if no one can prove who's the sovereign, whether it be the state, whether it be the federal government, or it's you, then you have no immunity from the law. You have no immunity from the law. Yeah, you might win a ticket case or something like that, but you never really dealt with the real issue about your sovereignty. No one has dealt with the issue of sovereignty. All right, so we come to deal with that. Who has the true sovereignty? The true sovereignty, I'm here to tell you, is in the crown. The crown is the sovereign. Was the sovereign, has always been the sovereign, and will be the future. Will be in the future, as it was in the present, as it was in the past, will still be in the future. All right, the crown. I'm going to verify that from various sources. So please, 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 because it will affect you. It's going to affect you. Whether you want to or not, you can ignore it. If you want to, you can turn the page, you can leave a comment, whatever. Leave something. Let me know that you're listening to what's being said. Look past who's speaking today. Look what's being said by he who is speaking to you today in regards to your future. All right? your future. All right. The oath of allegiance is not to me, but to the Lord God, because when you take an oath, you take it so hopefully God. And we know God is supposed to be the creator of the universe. All right. As the universe as well as the earth. All right. We're here on earth. We're not in the universe. So we must find our God here on earth that makes reference to the God here of the universe, because he's the creator of it all. And the best reflection that I can see in regards to that personification is King Edgar the Peaceful, the person you see here. And he looks predominantly like me. As you see him here in Westminster Abbey, okay? Westminster Abbey, and we know Westminster is where the Westminster Charter originated from. And we know that the charter that you see was the charter of King Edgar the Peaceful, presenting his charter to the personification of, or the image of what we call Jesus Christ, which brings you on to the new minister's vital, what's called Liber Vitae, which means the new minister's book of life, or all those souls who are written in the book of life. We know October is the English month for the All Souls holiday. It's called All Souls holiday for the honoring and the worshiping and the remembering of all those who have gone ahead to the spiritual plane. All right. These are our saints. These are our ancestors. These are who we should be honoring, remembering, and pledging ourselves to. All right. Very important. So let's get on with this marvelous lesson. As you see me, King Edgar the Peaceful, as you can see, as you can see me, King Jefferson, i.e. and King Edgar the Peaceful are actually one and the same through what we call incarnation or personification or incorporation, whatever term you choose. I have incorporated in law by way of my certificate of incorporation, which is synonymous with the charter of all the laws that were incorporated from time immemorial, going back to the Kings of Wessex and the Plantagenet Crown. And all those laws that were derived from the Kings of Wessex and Plantagenet Crown were actually instilled in what we call the Magna Carta. And those oaths of allegiance or those pledges were carried on into judicial customs that we see here today in what we call North America. All right, on the state and federal level, which we're discussing now. So without further ado, let's get started. We're going to start with the most fundamental document that everyone should be familiar with. Everyone should be familiar with this document. If you're not, then get familiar now. Listen to the language. The Constitution of the United States is the supreme law of the United States of America. It supersedes, which means it replaced the Articles of Confederation. Very important. The nation's first constitution. So outside of the charter given to the proprietors, the concession agreement, the Articles of Confederation was the nation's first constitution, superseded by the Constitution of 1789. All right? Superseded by the Constitution of 1789. This is a fact. Originally comprising of 7 articles, it delineates the national frame and constraints of the government, which was, as we say, a weak government, a weak central government, right? The only power that it had was that was given or granted by the crown, which I'm going to prove. The Constitution's first 3 articles embody the doctrine of a separation of powers. All right? Separation of powers, whereby the federal government is divided into 3 branches. The legislative, consisting of the bicameral Congress. Article 1, the executive, consisting of the president and subordinate officers. Article 2, and the judicial, consisting of the Supreme Court and other federal courts. Article 3. All right, we know that the Supreme Court and the federal courts, i.e. district courts, and their circuit courts are only courts of of what we call review. They're not courts of general jurisdiction. Once again, I repeat, they are not courts of general jurisdiction. They are courts of review, whether by review of being forwarded to the district court or the circuit court, i.e. appellate court, or the Supreme Court under writs, or by way of what we call judicial review, or what they call certification. All right, we must understand that. Very, very important facts. These are all facts. All right. Then you have Article 4, and Article 5, and Article 6, which embody the concept of federalism, describing the rights and responsibilities of the state government. You hear that? Of the state's government, not the federal government, but the state's government. So the federal government speaks on behalf of the state's government. All right. That's why it's not a court of general jurisdiction. It's a court of review. All right. The state in relationship to the federal government and share processes of the constitutional amendments. Article 7 establishes the procedure subsequently used by the 13 states to ratify it. 13 states. The Constitution of the United States is the oldest, longest standing, written, and codified national constitution in force in the world today. Key point, Articles 4, Article 5, and Article 6. Most important article, Article 6, because Article 6 embodies the concept of federalism, describing the rights and responsibilities of the state's governments, the states in relationship to the federal government, and the shared process of constitutional amendments. That brings us to Article 6. Article 6. Article 6 of the United States Constitution establishes that laws and treaties of the United States made in accordance with it as the supreme law of the land forbids a religious test as a requirement for holding a government position. It holds that the United States, under the Constitution, responsible for debts incurred by the United States under the Articles of Confederation. So the United States Constitution is no different than the Articles of Confederation, because the contracts are created by the United States should be the ones as created by the Articles of Confederation. Any other contract made contrary to that, it's an unconstitutional contract, or a contract that becomes null and void. All right. The text. All debts, contracts, engagements entered into before the adoption of the Constitution should be as valid against the United States under this Constitution as under the Confederation. Okay? The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary is notwithstanding. Okay, so as a citizen, you have the right to due process of law, and you have the right to be protected by law, right? Because we know that in the United States, in lieu of civil rights, in lieu of property, as well as persons or infants, that the overseer of the poor is the Attorney General. So when you go to receive due process of law in regards to civil rights, as the person, an infant, and minor at law, the representation should be by way of what we call the Attorney General by the state, or the Attorney General by the United States. You don't have representation by the Attorney of the state or the Attorney General of the United States, because you are being represented by a member of the bar, or organization, or corporation. So therefore, the interest in which they're representing is not on your behalf, but it's on behalf of the corporation for which it represents. All right, which is a violation of Article 6 on the court's behalf, as well as the judge's behalf, as well as those who represent in that court, i.e. the attorneys. All right, i.e. the judges are attorneys as well. The senators and representatives before mentioned, and the members of the several legislatures, and all executive judicial officers, both of the United States and of the several states, should be bound by oath or affirmation to support the Constitution. But no religious test should ever be required as to qualification to hold any office or public trust under the United States. Key word, oath of office. All right. Key word, oath of office. for the states and the United States, and as well as religious tests for an office in lieu of that oath. Because we know that there's a separation of church and state, so therefore the oath for the office of the state is different from the office and oath of that of a religious affiliation. You must understand that. Before I move forward, let's go to oath. Oath, as you said. Federal state legislators, executive officers, and judges are by the third clause of the article bound by oath or affirmation to support the Constitution. Congress may determine the form of such an oath. In Ex parte Garland, 1866, the Supreme Court held that a test oath would violate the Constitution, so it invalidates laws requiring the following oath. I, A, B, do solemnly swear or affirm that I have never voluntarily borne arms against the United States since I have been a citizen thereof. That I have voluntarily given no aid, countenance, counsel, or encouragement to persons engaged in armed hostilities thereto. That I have neither sought nor accepted, not attempted to exercise the functions of any office whatever, under any authority or pretended authority in hostility to the United States. That I have not yielded a voluntary support to any pretended government, authority, power, or constitution within the United States, hostile or inimical thereto. All right. Now, the Supreme Court found that the law constituted an unconstitutional ex post facto law, for it retroactively punished the offenses mentioned in the oath by preventing those who committed them for taking the oath. All right. Very important to understand what's being said here, because the United States and the states have taken an oath to uphold the Constitution of their states and the Constitution of the United States. And we know that the state's constitution, i.e. the 13 states, are preceded by the state's constitution, which were enacted predates 1789, in which the United States Constitution was ratified. Okay, we must understand that. That brings me to no religious test. Article 6 of the Constitution, which is the concept of federalism for the United States, as Confederate officers, known as senators, representatives, judges, etc. It says no religious test clause of the United States Constitution is a clause within Article 6, Clause 3, which states the senators and representatives before mentioned and members of the several states, legislatures, and all the executive and judicial officers, both of the United States and of the several states, to be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any public office or public trust under the United States. It immediately follows a clause requiring all federal and state officers holders to take an oath or affirmation to support the Constitution. This clause contains the only explicit reference to religion in the original 7 articles of the United States Constitution. The ban on religious tests contained in this clause protects federal officers and employees as well as office holders of state legislatures in the several states. This clause is cited by advocates of separation of state and separation of church and state as an example of the original intent of the framers of the Constitution to avoid any entanglement between church and state or involving the government in any way as a determiner of religious belief or practices. This is significant because this clause represents the word of the original framers even prior to the establishment clause of the First Amendment, i.e. religious freedom. So this is very important to understand it in regards to states immunity or the United States immunity clause, all right? Because if you're a citizen of the state or a citizen of the United States, then you cannot sue the states as a result of their sovereign immunity. For the state citizens, I'm gonna prove that, all right? Yes, they can be sued for torts, but the torts in which you can sue them under is based off what they call the amended statute, but not the Constitution. Why? Because the origin of the Constitution and the language of the Constitution goes back to the original intent of the framers' mind, which at that time were colonies. under the Articles of Confederation as established by Article 6. And at that time was under the laws of the crown, i.e. the common law of England, which I'll prove it to you in a second. All right. So I hope everybody caught up with that brief understanding about the origin of the Constitution as we see it today. All right. But understand that it has a dark secret that we do not know, which is going to be revealed today. And it's going to be validated by the United States Supreme Court. And we know the Supreme Court is one of the original offices as established in Article 6, pursuant to the Article of Confederation as established in the United States Constitution, which superseded the Articles of Confederation. All right. Very, very, very important for all those who claim to be constitutional scholars. And when I say constitutional scholars, I'm talking about all those who went to school for this. All right. You lack this understanding of your place in this government. All right. You're not considered as a part of the government because you don't know the origin of the government, because the government was established by the crown. I'm going to prove it to you. First, we must understand how important it is for an oath of office. All right. An oath of office in the origin of an oath of office. We know the oath of office for the United States is validated by what we call Article 6, now has been codified, which we'll discuss in a second, for those who are what they call state citizens or colonies, citizens of the colony, or citizens of what we call the United States. That don't apply to English subjects, all right? This does not apply to English subjects. English subjects, in lieu of the separation of church and state, which no religious text can be requested in regards to those who are subject to the church. And we know the church is headed by the crown, and the crown is headed by what we call the corporation soul, which is represented by the minor, i.e. the king, i.e. King Edgar Jefferson, the reincarnation of King Edgar the Peaceful. So in order for us to understand the origin of oath relative to the church, we must go back to the history in regards to the oaths relative to the church and disregarding that of the state as we see it in this modern day. I hope I said that well. Please, let's move forward. We know the United Kingdom was called Great Britain. In 1707, with the Treaty of Union, prior to that, there were separate parliaments, England, Ireland, and Scotland. All right, there were separate parliaments. England is not the British Parliament, and British Parliament is not the British colonies. All right, England is not the British monarch, and the British monarch, or the British what they call the British United Kingdom, what's called the Kingdom of Great Britain. The Kingdom of Great Britain was a uniting, as I said, England, Ireland, and Scotland. And we know that in England, Ireland, and Scotland, and the monarchs who were sitting as the sovereigns of the kingdoms of England, Ireland, and Scotland, all had what they call ceremonial preferences for their institution, what we call an oath of allegiance. All right, which is synonymous with what we call a judicial or official oath in this present day. We must understand that. All right. For all those who are state citizens or United States citizens or naturalized citizens, you already know what your oath is and your allegiance is to. All right. Well, I'm talking to English subjects. All right. For all those who are not English subjects and don't classify to the latter, then you are in a world of trouble. You are in a world of trouble. Okay. The oath of allegiance is a promise to be loyal to, as we see it in the United Kingdom and the Kingdom of Great Britain from 1707 up to this present day. It states that in his or his era, it says is a promise to the loyal to the British monarch and his or her heirs and successors, sworn by a certain public service in the United Kingdom. and also by newly naturalized subjects in citizenship ceremony. Okay, all right. So as we can see it in the United Kingdom, it's no different than what we see here in the United States versus as you being what they call a naturalized citizen. And when you're a naturalized citizen, you're not a national. Once again. So if you're a citizen of the United States from the Naturalization Act of 1790 and the process of ceremonies created through naturalization, you are still a foreigner here in the territory assumed to be called America, which is not America because I'm going to prove it. Okay. The current standard wording of an oath in allegiance is set out in the Promissory Oath Act of 1868 as reference to those in allegiance to the British monarch. We know the British monarchs were preceded by the English monarch, and as English subjects, we shouldn't use those as a reference point or as a directory. We should use English monarch as a directory because their influence here still affects us today as it regards to what we said as we know as the Magna Carta. How we know that? Because when I incorporated the English Third Temple Church of England, we incorporated under the laws going back to the Magna Carta. Okay? The Magna Carta. We ain't gonna read the text. Let's go back to the origin or the history dealing with the oath as regards to the English monarchs, not the British monarchs, but we're not British subjects. We're English subjects. All right. We know that oaths to heirs and successors. Let's read it. This oath is generally sworn to the crown, the monarch, or the sovereign, or the regent, which is synonymous. The crown, which is the monarch, the sovereign, or the regent. Let's just hit the crown real quick because the crown is a corporation soul, which is one natural person. Okay, through incorporation, which is the personification or incarnation. The concept of the crown as a corporation soul developed first in the Kingdom of England as a separation of the physical crown and property of the kingdom from the person or personal property of the monarch. It spread through English and later British colonization and is now rooted in the legal lexicon of all 15 Commonwealth realms, their various dependencies, and the states in free association with them. Okay, so this is subject to what we call the King's Jure Regalia. And the King's Jure Regalia under the King's radical title, which means the King's radical titles and the authority governed under his Jure Regalia governs the 13 colonies. Look it up, Jure Regalia and radical title. That'll bring you to that understanding of the power of the corporation, so which represents the crown. Okay. All right. So we know crown, monarch, and sovereign is synonymous. All right. We know it's a corporation soul, and the corporation soul is one natural person. All right. Now we know, let's find out the history, a brief history of oath, according to the English history, because we already disqualified the states, the United States, the naturalization process, or any other process for that matter, in regards to the citizens here in this particular land. All right. So take your pick what citizen you want to be, or what subject you want to be, or what person you want to be, or what individual you want to be. You still have to be classified under some family. All right. If you watch my last lesson about species, living organisms, all right, it's governed by your genetics. All right. And we know genetics deal with the family. We know family deals with the classification or who you claim to descend down from, not on the physical level, but on the DNA level. And the DNA level deals with biological understanding of who you are. Okay, so I can deal it on all levels. I've done it. You tell me one teacher, one scholar who have yet to do that, but yet, as they said in the scriptures, Jesus got no honor in his own house. All right. When they came there, they don't recognize who Jesus was. There's a picture right there in All Souls College of Jesus Christ, and people don't even know who this is who he was. All right. Okay, let's continue. History of the origins of oath or allegiance. All right. Make sure you see it. My stomach is growling. The oath of allegiance was performed to King Edgar by the common law. Pay attention, the common law. All right. The New York Constitution validates that. New Jersey Constitution validates that. Every colony within the state should validate the authority that was here in this land as described as the common law. Because Smith, Alabama states that, Smith versus Alabama states that there was only one common law, and that was the common law of England, and all the states has adopted it as their municipal law. So if you are subject to a municipal law in any state, then the only law you should be subject is the common law of England. And if they violate that common law of England, then that's a violation of their oath. And that means that the state court is unconstitutional, which means that they should be removed to a constitutional courtroom. If the United States courtroom, either district court or Supreme Court, is not acting as a common law, then they themselves are unconstitutional because they're only there in actuality are administrative courts mingle with executive and legislative and judicial tendencies. All right. They got the tendencies of executive and legislative judicial branch, but it's not that of the government, which means that it's arbitrary. All right. The oath of allegiance was performed to King Edgar, and we know King Edgar is Jesus Christ to us. All right. We know Jesus Christ was the Son of God, and God and Jesus were synonymous because they were of the same pedigree, of the same family, of the same species. And they were, so Jesus must have been a God. And when all monarchs, all officers, all judges take their oath, they take their oath, so help thee God. All right, very, 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 very important. So if America was founded from England, so when they was praying or taking the oath to God, this is the oath that they were taking to King Edgar. They didn't tell you that, but I'm telling you, this is who they were making their reference to, or their honor to, or their pledge to. All right. The oath was certainly in use as of the date of King John's Magna Carta, signed on 15th of June in 1215. Okay. Once the term has been finalized on June 19th, the rebels again swore allegiance to King John. The later Bill of Rights, which influenced the Scottish monarchs, which was carried on over here to what we call the United States. The later Bill of Rights, 1689, included an oath of allegiance to the crown. Did you hear that? Which was required by the Magna Carta to be taken by all crown servants and members of the judiciary. Okay? Members of the judiciary. So I repeat, once the term had been finalized on June 19th, the rebels again swore allegiance to the King John. We know King John was son of Henry II. Henry II was son of Godfrey, and Godfrey was the fifth kind of band Jew, where I descend down from, because we know the word Godfrey means Jefferson. We know Jefferson means the son of peace. We know that the Plantagenets in the crown were all kindred to the kings of Wessex, through Margaret of Scotland, who was the great-grandmother of William Edward the Confessor, the son of Ethelred the Unready, the son of Jesus Christ. How do I know this? Why? Because I am family. All right. So we know once the term has been finalized on June 19th, the rebels again swore allegiance to the King John. The later Bill of Rights in 1689, which is presently, all right, included an oath of allegiance to the crown. So if you're not taking your allegiance to the crown, as all English subjects should be doing, then you are committing treason. And if you're committing treason, then that means that they can issue bill of attaiндers on you. We all know what bill of attaiндers are. All right. This is why your rights are taken from you, because you don't have any rights. All right. Which was required by the Magna Carta to be taken by crown servants and members of the judiciary. So if the members of the judiciary had to take an oath, let's visit those requirements by the judiciary as established by the statutory law on the state level and on the federal level. Okay, let's do so. And don't forget who the oath was to: King Edgar the Peaceful. Born in 943 and died in 975. Everybody see that. We talked about that. You do your own diligence to bring yourself up to speed in regards to your ability to be able to be protected by these preservation of rights that were known throughout time immemorial. Okay, let's move forward. First, let's deal with the New Jersey. All right, in New Jersey, and we had the Virginia plan and the Jersey plan in regards to the foundation for which the United States became a confederacy. And you know, within that confederacy, being a weak confederacy or weak central government, their authorities still lied under the binding contracts, which was supreme law of the land, do what we call law and treaty, which they were subject to, as we see in the United States Constitution, as established in Article 6, which, according to Article 3, all judges, not just judges, senators, etc., are obligated to as well, going back to what we call the oath of allegiance. And we know why, because we're about to visit the statutory law in this present day to validate the authority that they were under in regards to this requirement, which was an oath. All right. New Jersey. 2021, Title 41, 28-6, colon 28-6. Everybody look it up. All right. Very important, because this is going to be the foundation for your salvation. This statute restores your sovereignty. Why do I say that? Because under the 1776 Constitution of New York and New Jersey, which predates the United States Constitution, and their Constitution boasts framers of those constitutions was looking for a reconciliation with Great Britain, which was not reconciled at the time as a result of the Revolutionary War with the British monarchs. Okay? But their hope was for a reconciliation with Great Britain, which would void out that constitution. So if that's the case, then we're going to see through a Supreme Court of the reconciliation, as well as through case law from Supreme Court. I think both from Supreme Court, if not, might be from the appellate court or the district court, one of them, in regards to qualifying that the reconciliation in New Jersey and the reconciliation of New York has been confirmed. It has been reestablished. I'm going to prove it once and for all, because we know in Article 6, all the judges of the states, as we said, and we broke down, what was it? Article 6, the religious test. Article 6, pursuant to the Constitution was encompassed the states' relationships to the federal government. That's all it encompasses. The state's relationship to the federal government, because the federal government put in place to keep the state in check. That's why the federal government and the courts of the federal government is a court of, it's not a court of general jurisdiction, it's a court of review. All right? It's a court of review. The only court of general jurisdiction are your state's courts. All right? But your state's courts are intermingled with the executive and legislative and the judicial power of a de jure government, being though it was de facto because it was an administrative government. All right? Function on administrative rules and administrative regulations, which is a violation of Article 1, Section 10, because these were called ex post facto laws. Once again, ex post facto laws. So as we see here, dealing with the oath of the states, all right, judges, as of the Chief Justice, the Associate Justice of the Supreme Court, the judges of the Superior Court, the judges of the Tax Court, the judges of the Municipal Court, and the Circuit, Deputy Circuit, and Special Deputy Circuit shall, before entering upon the execution of their respective offices, take and subscribe the following oath. I, whoever you are, do solemnly swear that I will support the Constitution of the state and the Constitution of the United States and will perform the duties of my office faithfully, impartially, and justly to the best of my ability. So help me God. So they're taking the oath to God to obey the state's constitution and the United States Constitution. We know that the state's constitution predates the United States Constitution because the United States Constitution came in 1789 through the Articles of Confederation, and the Articles of Confederation at the time were colonies. They were not states. So that's a violation of your oath to God. And who was God? The God was the king that was ruling at that particular time. How do we know that? Because we know that the origin of oath under English law, everybody speaking English, goes back to King Edgar the Peaceful. And King Edgar the Peaceful in the abstract was God, but in the concrete, he was a man. Because God was in the image of a man, because God said he formed, that's it, what it said, and begin with the word was God, and the word became flesh and dwelt amongst men. All right? So if you're a man, you must understand God, and to understand God, God must be man, and man must be God. All right? We must understand that. Let's look at the federal level. You're not going to get it nowhere else like this. This might be about 2 hours long, so y'all better listen. Each justice, let me make sure you see it. This is Title 28 United States Code, Section 453, Oath of Justices and Judges. Each justice or judge of the United States to take the following oath or affirmation before performing the duties of his office. I, blank, 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 whoever you are, do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as provided under the Constitution of the laws of the United States, so help me God. So if you swear to the Constitution of the United States, then you got to swear to the laws of the state, because we know that the Constitution of the United States in 1789 is just a constitution showing the relative or related relativity of the states to the federal government in regards to the obligation as prescribed by the Articles of Confederation. Because all that is a resemblance of the Articles of Confederation, which at that time was the weak government, and only authority the power they had at that time was the power and authority underneath the crown. So everybody take the time to wrap your head around that. Okay. It's proved that the United States has waived their sovereignty, as well as the state of New Jersey, as well as New York, has waived their sovereignty. But they're still protected as a result of what we call sovereign immunity. Sovereign immunity, you cannot sue as a result of your affiliation to the United States or the state's government, because you are a citizen. So you can't sue your origin. You can sue them for torts, right? But you can't sue them for a tort under the Constitution and in the parameters that I'm giving you, all right? You can only sue them in tort under parameters that they set as the guideline for bringing remedy to those who are injured by agents of the United States, i.e. the federal government. Very important to understand that, and I'm gonna give you a case law to provide you with that understanding in regards to those who come to this clarity of what I'm giving you, right? And try to use a remedy that was provided for the information that I'm giving you in regards to the authority at that time when the court was corrupt, was the only remedy at that time that could be provided for any private citizen was a writ, all right? A prerogative writ, whether it was a writ of mandamus, a writ of quo warranto, a writ of circulator, what else? A writ of or whatever other writ that's out there, writ of mandamus, writ of circulator, a writ of habeas corpus. All those writs originated from English common law. The administrative courts have adopted that process, but take the essence out of the writ. Why? Because the origin of the writ was left up to the authority of that which is called the King's Bench, which Supreme Court of New Jersey was powerless to sever, as what I just showed you in the court law. And the Supreme Court can do nothing about it because all judges were obligated to honor the United States Constitution. And we know the United States Constitution is just a constitution binding the states' governments to the federal government in lieu of the state's constitution, which was rooted in the framers' mind before they even became a confederation. Y'all better understand what's being said. New Jersey, 2019, 2021, 2023, you can look it up. It's still there. Waiver of immunity from liability in contracts. It says under 59.13.3-13-3 of the New Jersey revised statute, we know revised statutes are code of legislations that were derived from the amending of the Constitution. All right. Whether you're talking about New Jersey's 1947 Constitution, whether you're talking about New Jersey's 1844 Constitution, or you're talking about New Jersey's Constitution of 1776, all right? Or New York's Constitution of 1777, or any other amendment constitution that came thereafter, all right? Both constitutions clearly state, as well as the United States Constitution, clearly states that the sovereign immunity already automatically is waived as a result of you can be sued by torts. But the tort and the parameters of the torts is what needs to be questioned, because us as the English heirs cannot sue under the tort of the United States because the remedy that you receive will not be based off what's kindred to what's provided under English law in regards to governments and put infractions upon me, because this is a violation of antitrust law. There was law put in place, and if antitrust law is violated on behalf of the English nation, it's the Attorney General who's supposed to be speaking on behalf of the violations of your civil rights in lieu of your property and yourself or your persons. All right. It's the Attorney General who's obligated to do that. Why? Because he's preventing paratiate on the state's level or on the United States level. If it's not on those two levels, then the only level that you can seek it is the crime. All right. For all those who want case law to support that, see Barbich versus Barber. Barbich versus Barber. That's case law for you. So as you can see, New Jersey hereby waives its sovereign immunity from liability arising out of the express contract or contract implied in fact in consent to have the same determined in accordance with the rules and of laws applicable to individuals and corporations. Provided, however, here comes the sovereign immunity part, that there should be no recovery against the state for punitive or consensual damages, let me say that right, consequential damages arising out of contract, nor should there be any recovery against the state for claims based upon implied warranties or upon contracts implied in law. All right, so that's that sovereign immunity. All right, we know that all states now function under what they call their commissioner, all right, which is created by what we call the governors under color law as a result of the administrative government, as I said, mingle with what we call legislative, executive, and judicial tendencies. All right. But they're unconstitutional. And as a result of that, as Judge Vanderbilt said, that private citizen can remedy those defects by way of a prerogative writ, such as a court warranto, writ of mandamus, writ of circulator against the state, where no such sovereign immunity exists, right? Because we know that all officers of the state, United States, are subject to the crown as a result of their oath to God. And we know God is represented by the crown, which I'm going to prove to you in a second. Tort action of the United States. Real brief. Tort actions against state officials. The judicial power of the United States should not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. This can only be ramified or rectified by understanding the history of the United States. Because if you understand the United States as the starting point of history of this country, then you are doomed. All right? You are doomed. Now you're down in the 11th Amendment, all right? Which contradicts the 6th Amendment and all the contracts that were created and prescribed and qualified and substantiated under that. Going back to what we call time immemorial. If you understand the concept of time immemorial with the contracting parties that was created in time immemorial based off that oath that these judges, i.e. senators, governors, or Republicans, or House of what they call House of Commons, whatever term you choose to call them, they are all de facto, and surely, as you hear me speak today, they will be removed. Okay? They will be removed. Okay, let's move forward. So let's go ahead. Villains versus Harris. No, let's do War versus King. Everybody needs to understand what's being done. Excuse me. Chief Judge Vanderbilt was the Supreme Court judge and Chief Judge of the Supreme Court. All right, in 1947, by way of the ratification of the Constitution of 1844. All right. We know the ratification of the Constitution of 1844 was the ratification of the Constitution of 1776, and under the Constitution of 1776, in New Jersey, adopted the common law of England. And Article 22, the common law of England, which was the law of the land, clearly states that the true intentions of that Congressional Convention was for the reconciliation of Great Britain. Once the issue of the British subjects, the British conflict that was going on at that particular time with the British monarchs was resolved. Okay, there was supposed to be a reconciliation with Great Britain, the King of England, not Ireland, not Scotland, but the King of England. I'm going to prove it. There was a case brought forth by one of the officers of what we call the city of New York. He was a police officer. He was the plaintiff in the complaint. And the plaintiff filed a complaint in regard to corrupt that was going on inside the municipal police department. So he took a leave for 3 months from February to May. And on this leave, absence of leave, he didn't even take pay. And on this leave, he went and ran for an election for the city, be elected for the commissioner. But he wanted to be elected for the city commission, all right? So that he could do something about the problems that were going on in the police department in regard to corruption and grabs. All right. This was the complaint that was brought forth by the plaintiff in the complaint. All right. So let's get a brief discussion about a plaintiff, an employee of the city's government. All right. If he's employed, then you know he's a citizen of that state's government. All right. Once again, let's look at the facts here. Plaintiff had a problem with what was going on with the state's agency, i.e. a state's police government, which is supposed to be protecting you. And he's out there commissioning to be elected for the city's commission, to be able to be sit on the board, to be able to bring issues like this arising for corruption in the government. He was considered what they call a whistleblower. All right. He's one of the individuals who are trying to consider what they call bringing forth what they call a bill of peace. All right, consider a bill of peace. Give me 1 second. All right, yes. So let's read the complaint, not in its entirety, but in its context, and get an understanding of the issue that resulted in the Superior Court by way of filing the prerogative writ, which we're going to see in this case that was the most powerful tool to bring a remedy, not in this case, all right, but in the case of a private citizen. But they're going to show you in this case that the plaintiff in this matter has committed treason against his newfound citizenship of the what we call the state of New Jersey, as well as being affiliated with the United States, because Chief Judge was the judge of the state Supreme Court. All right, I'm going to show you case law from the United States Supreme Court of New Jersey in regards to the rights that English subjects had in regards to bringing remedy to issues that arises from administrative governments who are claimed to be governments on behalf of statutory laws known as rules and regulations, mingle with legislative and executive and judicial tendencies. All right, but are indeed valid upon the face once being inspected in the court of review. And this is a court of review. You're now sitting at the King's bench. So let's read it. In fact, the plaintiff, a police officer of the city of New York since 1924, applied for and was granted leave of absence without pay for a period from February 1st to 1949 to May 31st to 1949 to enable him to become a candidate in the city commission election in Newark on May 10th. In the course of the campaign and while on leave and absence, he distributed literature. He made several speeches and radio addresses in a number of which he asserted both generally and specifically that there was corruption, graft, and misconduct in the police department of the city of New York, and charges his superiors with knowledge and participation therein. So what he was doing, I'm doing. He was doing it on his level, and I'm doing it on my level. You should be doing the same or taking the same position that this citizen was doing in lieu of a private citizen, which he was not, come to understanding his citizenship. Therefore, you should understand your citizenship and the ability to be able to ramify your right to due process of law as a citizen and understand the effects of why you're not getting the results you need as a result of you not understanding your citizenship here in the citizenship that they give you as a requirement for due process to law. It's unconstitutional. I'm going to show you. All right. Judge Vanderbilt is going to show you. It says, let's see, what was I at? Charges period with knowledge and participation therein. So just as the participants and the corruption on the city level or municipal level has trickled, has filtered up to the federal level, because it starts on the municipal level. All right, it starts on the municipal level. So most of the corruption that's done, that's being exemplified on the federal level, starts on the municipal level. In the middle of the campaign, and while the plaintiff was still on leave, the chief of police, it might as well be the chief judge, called him and requested him to furnish details with respect to the charges he had been making. But the plaintiff refused to answer any questions, right? He pleaded the fifth. He leaves up, his leave of absence was not revoked though. However, he was permitted to continue with his campaign. So the chief of police called him out on regards to the information that he was propagating while on leave by way of what we call literature, general appearances, as well as speeches. All right. So this chief police might as well have been the chief judge once you hear the decision by the chief judge, i.e. Chief Vanderbilt, in regards to the plaintiff in this matter. All right, because he thought he had the ability to be able to bring the whistle on the corruption on the state's government. But the chief judge in the matter said, no, you cannot. You will not put this thing in my plate. I don't want to be the one to be able to deal with this issue. This is the issue that all the New Jersey is having with me right now. But I'm not in the same position as this police officer, the plaintiff. Why? Because I'm the private citizen is able to remify what the police officer was trying to remify, and a different jurisdiction where the state or the United States cannot claim sovereignty, because in the jurisdiction where I'm arguing, they have no sovereignty because of the understanding of sovereignty. All right? Because we know that sovereignty is either the monarch or the sovereign or the crown. And I'm going to show you through case law. All right. On June 21st, the first day of his return to active duty, the plaintiff was served with the departmental charges preferred by the chief of police and was suspended from duty without pay pending hearing of these charges. So that means that when the plaintiff got back from his absence of leave in regards to his campaigning for be a part of the city commissioner to bring to clarity and bring to light the corruption that was going on in the police department, and the superiors understanding what was going on because they were a part of the corruption, he was brought up on charges by the chief of police, and he was suspended without pay, pending a hearing of the charges with the police department. All right. The charges, all of which are founded upon the violation of departmental rules and regulations, which were 6 in total. 1, willful disobedience of orders and failure to report crime to his commanding officer based upon his refusal to answer the questions put to him by his chief officer. 2, neglect of a duty and failure to report the commission of a crime based upon a radio address made on April 4th, where he professed to know the names of certain violators of the law. You hear this, y'all? 3, failure to take proper police action to divulge information to his superior officers based upon a broadcast made on April 11th to the effect that narcotic peddlers were operating in Newark. 4, failure to take proper police actions to divulge information to his superior officers based upon a statement made in the same broadcast in which he publicly named the numbers of alleged gamblers still at large. Why would you bring these arguments up to the people who are committing these offenses? That'd be an easy way to take him out. All right. So I agree with the citizen, i.e., of the what we call the municipality of the city of Newark. All right. I agree with his action. All right. His actions, though good, will not come to any avail as a result of his ignorance of law and citizenship, which we discussed in a second. 5, conduct contrary to good or order and discipline in making a false and inaccurate statement in broadcast made on April 18th and May 9th concerning the handling by the police department of a case of a person arrested for carrying concealed weapons. And 6, public disparagement. All right, so I'll read fast, so public disparagement and unfavorable comment on the official action of the Director of Public Safety, whom he charged in the course of a broadcast on May 9th with neglecting his public duties. Very, 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 very important. So that means that upon complaint brought forth by the chief of police, he was suspended without pay, pending the hearing with the director of police, director of public safety, as well as the commission. All right, the commission. So the plaintiff brought suit in the Superior Court. I'm gonna move forward. Right. Prior to the date, let me just move forward in this case. Okay. Prior to the date set forth in hearing of these department charges by the Director of Public Safety, King and the plaintiff commenced the present proceedings in lieu of a prerogative writ. All right. He filed a writ. He wasn't playing around. He wasn't trying to go through the administrative processes because he worked there. So of course he understands the colorableness of his job. All right. But what they say, but good for the goose is good for the gander. All right. You was laid, you were a product of the goose. All right. You got the DNA of the goose. You got the genetics of a goose. You came to be a part of another species when you already agreed to act as this species. All right. As that classification under that order or rule or conduct. You already agreed to. Now you automatically trying to jump ship. This is what you all who are viewing this lesson, who all don't view this lesson, is going to find yourself into. Because I know where you are at. If you are not a member of the English Theological Church or of England, or not an ancestor of English heritage based off ethnicity or genealogy on the genealogical level, dealing with family descent, as well as on the biological level, dealing with cellular descent or lineage, then you are in a world of trouble. Okay? You're in a world of trouble. All right, let's continue. It says that he brought prerogative on June 17, 1949. On his motion, a summary judgment was entered in his favor, vacating his suspension. This is Superior Court, y'all, as well as the appellate court, because the defendants appealed the action which brought before the Supreme Court. All right. It says directed. It says on 27th of 1949 on the motion for summary judgment was entered in favor of the plaintiff, vacating his suspension, directing his reinstatement, and ordering that the charges against him be expunged, and that the defendant director of public safety be permanently enjoined from conducting any hearing on these charges, and that the board of commissioners reimburse him for losses of his salary between the date of his suspension and his reinstatement. From this judgment, the defendant took an appeal to the appellate division of Superior Court. That appeal has now been brought here on our own certification. And this certification was in the Supreme Court. All right, Chief Judge Vanderbilt. He's the Supreme Court judge. Let's go to the meat. Same case. The doctrine that a litigant must exhaust his administrative remedy before he may resort to the courts date back to the advent of the Interstate Commerce Commission of 1887. Okay, so if you file a complaint in regards to injury that was committed on behalf of any officer of the state or on the federal level, any officer on the federal level, then if it falls under the administrative remedies, then you must exhaust those remedies first before going outside of the remedies as established by way of the agreement that you created by way of contract. We know that the states and the United States have waived their sovereignty and agreed to be tried on the level as individuals or corporations. We know that the United States is a corporation, it's an administrative government, it's mingled with executive, legislative, and judicial tendencies. Why? Because this is what Chief Judge Vanderbilt said in regards to administrative remedies, in regards to the issue that the plaintiff was dealing with, in regards to corruption going on by the HE in which he worked for, which was the HE of the state under the authority of the federal government, because we know that the relationship of the Constitution is a relationship between the states and the federal government, all right? Which the district courts or the circuit courts of the federal government are only courts of review. They're not courts of general jurisdiction. The only courts of jurisdiction is the Superior Court. We know the appellate court is a court of review, all right? The doctrine that a litigant must exhaust his administrative remedies before he may resort to the courts date back to the advent of Interstate Commerce Commission of 1877. and the exception of the modern phase of administrative law, marked by the creation of commissions with commingled legislative, executive, and judicial power as distinguished from the traditional body of administrative law by which officials and bodies in the executive branch of government, both at the local and higher level, were kept within their respective spheres and were held to the methods prescribed by law by a series of remedies in the courts ranging from prerogative writs and bills in equity for injunctions to suits at law for damages. Did you hear that? Did you hear that, y'all? You must understand what's going on in regards to your remedy that you seek, because even if you file a writ in a court of law under the administrative law, you're not going to get the same production as a writ filed under the administrative law of a lawful and de jure government, all right, as distinguished here in Bellins versus Harris. He just clearly stated that the administrative concept of due process of law originated with the Commerce Commission of 1887, and the exception of modern phases of administrative law marked by the creation of commissions with the commingled legislative, executive, and judicial powers as distinguished from the traditional body of administrative law by which officials and bodies in the executive branch of government, both at the local and higher level, were kept within their respective spheres and were held to the method prescribed by law as a series of remedies in the courts ranging from prerogative writs and bills of equity for injunctions to suits of law and damages. Intended as a simple rule of orderly procedure designed to provide uniformly that administrative bodies might perform their statutory functions without preliminary litigation and administrative parts of preliminary litigation, and the rule insisting on the exhausting administrative remedies has been highly prerogative of litigations that show no sign of abating from year to year or producing the tendencies, simplicities, and uniformity for current instances of waiverness of federal decisions under the rule. Without attempting to commit on all cases, we will content ourselves with referring to Myers versus Bethlehem of shipbuilding, holding that the doctrine of exhausting administrative remedies applies even to cases where administrative agencies has to pass on questions of its own jurisdiction. This holding has been recently reaffirmed in Security Exchange Commission versus Otis Company, where the United States Supreme Court reversed without opinion a decision of the United States Court of Appeals for the District of Columbia to the contrary, where the question of jurisdiction depends, as it is often does, on questions of facts, and where federal courts apply their versions of the substantive evidence rules, which often signifies something falling far short of a weight revealed to the question of jurisdiction and may be little more than pro bono. All right? Very, 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 very important. Hold that thought. Y'all be we got in a second while I get with some more. That's good. So the discussion is whether a person has to exhaust their administrative remedies as established by the Commission of 1887. All right. And all this in regards to the use of a prerogative writ. All right. A prerogative writ. I got a letter right here from the Supreme Court of New Jersey. Let's see. Supreme Court of New Jersey. This office it states to Clifford Jefferson versus City and the State Department of Health Vital Statistics, ETAL, Supreme Court docket number 087371. And this is the case that's in the district court now as a result of federal questioning, as well as what they call equal protection of law, pursuant to prerogative writs, which we're talking about. All right, we're talking about prerogative writs as an instrument to be able to remedy some to bring on the question of what we call a writ of mandatory warrant or order to show cause. Why something should not be done by an officer who holds a particular position under oath, or officer who violates that oath by doing some corruption that's contrary to the position in which he holds. All right. So I'm questioning the Supreme Court on something to review what they call, as I stated, Supreme Court do writs what they call petition for certification. This was a letter for petition for certification to demand the district court, i.e. the circuit court, i.e. the appellate court, to parts of not the appellate court of the district court, but the appellate court of the state court, to justify if the decision that they were made was right or just in regards to their decision. All right, their statement of order. And the letter wrote that I'm reading here says that the Supreme Court does not exercise the authority of prerogative writs. All right. Once again, the Supreme Court does not exercise the authority of prerogative writs. That authority was superseded by the amending of the Constitution of 1947 and now transferred to the Superior Court pursuant to Rule 4:69-1, where it says that, and I repeat, the appropriate procedure for seeking relief that was formerly available by prerogative writs is to file an action in lieu of prerogative writ with the Superior Court of Law Division pursuant to Jersey Court Rule 4:69-1 as a matter of right, not a privilege, but as a matter of right. So as you can see, this granted privilege as a matter of right in lieu of prerogative writ was granted to the plaintiff in this case, Brennan versus Harris. All right, and the state court and the appellate court. All right, and in regards to Article 6, Section 4, because I just read it here. Article 6, Section 4. Just read it here, right here. Enough can be said to raise grave doubt as to the wisdom of adopting the rule of exhaustion of administrative remedies as contended for by the defendant. To determine what rule of law should be adopted in the case before us, we must consider what was intended to be accomplished by Article 6, Section 4, Paragraph 4 of our Constitution of New Jersey. Paragraph 4 of the states that prerogatives are superseded. We know that the Constitution of the United States superseded the Articles of Confederation in March 4, 1789. We already seen that. Supersede means replace. So now we're talking about prerogative writs. Prerogative writs are superseded in lieu of thereof, review, hearing, and relief should be afforded in the Superior Court on terms in the manner provided by the rules of the Supreme Court. You hear that? So Supreme Court has abandoned ship. They have abandoned the ship, and they have abandoned ship, which is contrary to Bellin versus Harris. They have abandoned ship, which is contrary to a case law, Bellin versus Harris, which we discussed after we built this one, and show you that what the Supreme Court did was contrary to what the Supreme Court said, because the Supreme Court, the legislature was powerless to sever the power of the King's bench from the Supreme Court. But yet we're reading the Supreme Court stated in this case, as well as in this letter that I just showed you, that they no longer practice that authority that was granted to them by the king's bench. All right. It says prerogatives are superseded in lieu of thereof, revealed in hearing, and relief should be afforded to them in the Superior Court on terms and the manner provided by the rules of the Supreme Court. So the Supreme Court has set the rules for the Superior Court in lieu of Chief Judge Vanderbilt, who was the Chief Judge for the Supreme Court of New Jersey in 1947, which is the case we're reading right now. Y'all gotta give me my props. You gotta give me my props. Except in criminal causes where such review shall be discretionary. You hear that? Such in criminal causes, because they know if it's a criminal cause, they can be in trouble. All right? They can be in trouble. All right? So let's show you what Chief Judge Vanderbilt said about the prerogative writ that can be brought forth in lieu of bringing remedy to corruption that's being done on behalf of a public official. All right? But it cannot be brought on behalf of a citizen of the state of New Jersey as a result of your being a party to the contract. You are a member, you are a citizen, you are a partnership, you are a legal person that does not have any right in regards to being able to institute a prerogative writ that was set forth and known to be instituted by a subject of the crown. I didn't say it. Chief Judge Vanderbilt said it in the same case. Let's see. I got a lot to cover, so I'm going to move forward. Okay. Now we're going to discuss the effects of a prerogative writ. By the simple, by far-reaching device of permitting taken by disposition of evidence dehors the record. The Supreme Court of the Colony of New Jersey, all right, it didn't say state, y'all, colony. You were always a colony under the Articles of Confederation, all right? Has never changed. Made the writ of circulator a more generally useful instrument for correcting the mistakes of all too often unlettered justices of the peace that then it could possibly have been had. Pardon me, read that again. All right, start. By the simplest but far-reaching device for permitting the taking by disposition of evidence dehors the record. The Supreme Court of the Colony of New Jersey made the writ of circulator a more generally useful instrument for correcting the mistakes of the all too often unlettered justices of the peace that it could possibly have been had and been obliged to confine itself solely to the form of record brought up by a writ of circulator, writ of mandamus, writ of quo warranto, habeas corpus, etc. So the Supreme Court of the Colony of New Jersey made a writ of circulator an effective tool for being able to bring into question those justices or judges who claim under their newfound what they call claim of sovereign immunity under what we call tendencies of legislative and executive judicial protection, which were unconstitutional, as we've seen, as stated by Justice Vanderbilt. All right, Chief Justice Vanderbilt is going to show you that what the State Court of New Jersey and the Appellate Court of New Jersey did was a violation of the undermining of what the whole state stood for. All right, what the whole state stood for. It's stated here. This ingenious procedural device also paved the way for enlarging the scope of the circulator far beyond the mere review of the judicial action of inferior courts, so as to reach official misconduct in many fields. The origin of the practice of taking disposition is lost in the incomplete archive of our early judicial history, but we have been able to track it back as far as the case of Collins versus Webb. All right. right here. All right. Key part right here. The special significance of the broad scope of the prerogative which this with the circular court, with the circular court, which is in question, and specifically in New Jersey, and protecting an aggrieved citizen from almost every form of improper official action is epitomized by Hardworth and speaking of the prerogative which generally. Okay, generally, we know federal courts, district courts are not courts of general jurisdiction, nor the Supreme Court a court of general jurisdiction. They're only courts of review. But this review is based off Hardworth prerogative review in generally. He states that the judicial control and lieu of prerogative writ by a private citizen, all right? By a private citizen. The private citizen can set in motion the different forms of procedures open to the Crown. And in addition, he could bring a civil action. This power to bring a civil action was an effective control, a safeguard of the liberty of the subject, and one of the best of all securities for the maintenance of the supremacy of the law, i.e. history of English common law. Okay, so Chief Judge Vanderbilt says that the most effective tool that you can use in regards to remedifying the corruption done by administrative government, mingling with executive, legislative, and judicial power that they do not really have, the only effective way you can do that is by a private citizen instituting a private complaint, civil action, i.e. by whistleblowing. The same complaint that was brought forth by the plaintiff in this case on behalf of corruption committed by the state and his municipal agencies and his municipal agents, all right, i.e. the officers and the senior officers or what they call superior officers are what they call are knowing of the injuries that are being done on behalf of the claim was filed in the first place. All right, so it's very, 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 very important to understand what the Chief Justice of the Supreme Court of New Jersey said in 1947, in ruling on the case of a assumed citizen bringing a case on corruption in the state's government and trying to bypass the state's sovereign immunity to complaints brought forth by a citizen of that state or the federal government as well. All right. And we're going to see the decision made by Chief Justice Vanderbilt on regards to the prerogative writ, which Judge Holdworth epitomized that the most effective thing that can be done is to bring a prerogative writ to bring those who are violating the rights of a private citizen. And the only way he can do it was to file that under procedures that was bestowed by the Crown as the most effective power in bringing civil action and to control and safeguard the liberties of its subject, which is one of the best securities of the maintenance of the supremacy of the law. Okay, you see right here in this case. So let's see what the decision of the judge that were made on behalf of what we read in here on behalf of the Crown, because we see Judge Vanderbilt preserving the remedy under the Crown, but they're not acting under the Crown. All right, they don't have the legislative, executive, and judicial power of the Crown. They have the executive, judicial power, and the legislative and executive power under what we call the administrative government. All right, which is nothing more than a corporation, which I showed you the statutes because the state and the federal government had waived their immunity. All right, they have waived their immunity. All right. But we also know they have took an oath to uphold the state's constitution and the federal constitution in both jurisdictions. All right. But the constitution that they should be making reference to in lieu of that oath should go back to the Magna Carta, because we know the Magna Carta was under the authority of what we call the Crown. All right. It says here, it states that in lieu of the plaintiff's complaint filed against a civil complaint filed against the state police department for corruption which were reviewed by the Supreme Court, the conclusion or the decision or the statement in order that Chief Judge Vanderbilt gave on behalf of the plaintiffs in review of that which was forward from the appellate court and the general court of New Jersey, they stated that we conclude, therefore, that the plaintiff during his leave of absence was subject to the departmental rules and regulations that he is charged with having breached, that the charges made against him are not for this reason insufficient as a matter of law, and that the relief granted by the court below is erroneous. According to the judgment of the law, the division of the Superior Court is reversed. Did you hear that? You see how much trouble if this prerogative writ would have prevailed, it would have let the cat out the bag. Chief Judge Vanderbilt, as well as Justice Case, Justice Herher, Justice Leafitt, and Justice Burley, and Justice Atkinson all confirmed that they will not let this secret out, especially on one of their citizens. It's not happening. All right? The only one can bring this claim is a private citizen, which I'll show you in the court case in the United States versus Lake. All right, we'll talk about that in a second. Let's move forward. Let's go to another court case. As we can see, the corruption as established by Chief Judge Vanderbilt in regards to bringing a claim such as under this magnitude on the state government. All right. So the state government of New Jersey fell back on its immunity, but we know that the state don't have no immunity pursuant to New Jersey by statute 5913-1. It waived this immunity, but yet the plaintiff in this matter could not prevail as a result of him being part of the classification as established in 5913-3, which state that the state waived their immunity and to be tried on the same level as individuals in corporation in which the plaintiff was. All right. So on that case, we can conclude. Let's move to the next one. Ward versus Keeney. I'm sorry. That was Ward versus Keeney. Let's go to Billing versus Harris. This case will be quick. We're gonna move this just quick. This is by Judge Brino, a district court judge, a federal judge, a judge appointed under the Judiciary Act of 1789, a judge under the Constitution of 1789, March 4th, a judge subject to Articles of Confederation under Article 6, as established by the Articles of Confederation. All right. Same judge. All right. So whether they're state level or federal level, we know the federal level and the state level is just agreement between the state judge and the federal level as a result of them becoming perpetual union, as established under the Articles of Confederation, which is the Confederation of Perpetual Union, but under the weak and central government that was established as the 13 colonies. All right. Let's confirm this by Judge Brino, and we'll see Billis and Harris, which is a case heard by who? The District Court of New Jersey in 1980. This is present, y'all. This is modern day. Okay, all involving the review of administrative agencies or exhaustive remedies on the administrative agencies, as we see in Ward versus Keenan, as rendered by Chief Judge Vanderbilt. Okay, it's all dealing with administrative agencies' ability to be able to act as de facto governments under the auspices of a de jure government, without the de jure government officials in their capacities acting in the capacity as they took an oath to, as we established in the state statute and the federal statute. Okay, those who haven't or new to the video or just got here, please refer to the beginning of this video. Okay, It says here, in which the district court is reviewing, because we know a district court is the court of limited jurisdiction. All right, it's only a court of review. It's not a court of general jurisdiction. Only states courts are courts of general jurisdiction. The evidence consists of the records of proceedings before the administrative agency. So the district court, a federal court, a constitutional court, according to the Constitution, as we just stated, is reviewing a complaint of an administrative agency of administrative government. If that's not color, I don't know what is. All right. The rule of decision on review of that record is whether it contains substantial evidence to support the agency decisions in most cases, i.e. their orders, their rules, their decisions, their statement of reasons, whatever decision you get in an administrative court, those courts and those rulings are null and void. All right. In some cases, the review may include questions whether the agency decisions correctly applied governing law, including rules and regulations, i.e. were those laws constitutional, because no, the laws that they use is not constitutional law. The laws they use is rules and regulations of the court, are stuck in the statute. All right. They just create rules and stick them in the statutes, having no validity whatsoever. All right. Constitutional from the door, unconstitutional from the door. And others may bring into question the meaning and interpretation of that law or its validity, or the constitutionality of one provision or another, or of the procedures employed. You hear that? Since the federal courts are not courts of general jurisdiction, I keep saying that, possessing all the powers of the king's bench. Now, this is the district court judge, and in the 19th century, talking about the authority of the king's bench here in New Jersey. All right, here in New Jersey, we know Chief Judge Vanderbilt was the chief judge and a judge in New Jersey under the district court under the Constitution of 1947, preceded by the Constitution going back to 1776. All right. It says, since the federal courts are not courts of general jurisdiction possessing all powers of the king's bench, the accumulation of precedents in the general field is somewhat nebulous, especially since the law in each of the circuit courts is controlled by decisions of the courts of appeals and the particular circuits until such time as a decision of the Supreme Court of the United States dissolves differences between the circuit courts. The Supreme Court and the circuit courts are unconstitutional courts. Why? Because the authority in which the Supreme Court get their authority from derives from their affiliation with the state courts, because they're not courts of general jurisdiction. They're only all courts of review, which review the courts of lower jurisdiction. The state of New Jersey, whose boundaries coincide with those of the district, is one of the original 13 states of the Union, i.e. the Articles of Confederation, i.e. the perpetual Union, going back to Articles of Confederation pertaining to the United States Constitution, Article 6. All right, Article 6. It says, the 13th state of the Union is a common law state. The structure of its laws may be looked to for the general background about prerogative writs in general and writs of circulator in particular, which we discussed in Ward versus Keenan by Chief Judge Vanderbilt, the chief judge and the first chief judge under 1947 Constitution rendition, what you call a rendition. King Clifford Jefferson, you on the roll today, boy. New Jersey's first constitution adopted July 2nd, 1776. For those in New York, look at the Constitution of New York, 1777, all saying the same thing. It says New Jersey's first constitution adopted July 7th, 1776, terminated its status as an English colony. It began its sovereign existence as a state. Article 22 of the Constitution continues the common law of England in force. That Constitution was replaced by the Constitution of 1844, modeled largely in structure and content on the Constitution of the United States. You hear that, y'all? By Article 10, Paragraph 1, it too continued enforce the common law, as well as the existing courts of laws and equity. So also the current Constitution of 1947, which we were speaking about in War versus Kingdom by Chief Judge Vanderbilt, first Chief Judge appointed by Governor Driscoll, Alfred Driscoll, under Article 11, Section 1, Paragraph 3, continue to enforce all existing laws. Did you hear that? All existing laws. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's bench. What happened? What happened? Why do you send me a letter sent from the King about the prerogatives of the King, and now you send a letter telling me that the prerogative of the King is no longer instituted in the Supreme Court, but yet has been transferred to the authority of the Superior Court under Article, what was it? Under New Jersey Court Rule 4:69-1. All right. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's bench, but the legislature was powerless to cut down or to assign to other courts. So I don't care what court you're going to. A court, if it's not going based off the common law of England, and if it's not operating off the authority of the King's bench, as set forth by New Jersey versus New York, which is another case I go to in a second, in regards to the Supreme Court has said that all courts was make preliminary procedures to establish the authority for the King's bench, especially in regards to quieting a bill of peace. All right, quieting a bill of peace. All right, this platform and everything we speak on this platform in lieu of the King's peace is for quieting the title. Quieting the title, quieting the title, or quiet title, or a bill of peace. A quiet title is a bill of peace. To put on the record once and for all who is the owner of all property. Because we know under Parsons, the Attorney General representing the state against versus Standard Oil Company, we know that the United States or the states are nothing more than custodians of property, do what we call bona vacatina, because we know that when all property of heirs is streets to what we call the state of the United States, it's a result of what we call estate as a result of what we call interstate, because there are no heirs. And if there's no heirs, then all property that is streeted to the United States cannot be abandoned by the state to be given to somebody else. It must be kept what they call in storage, or what they call unclaimed property. All right, which automatically falls under to the king when there are no heirs. I'll show you in a second. All right. So we see here that the legislative authority that was empowered in the King's bench was in the Supreme Court, and that any other legislative contrary to the legislature that put that power there in the Supreme Court that was instilled by the King's bench was null and void, or what we say notwithstanding. All right. So any courtroom that you go into is not under the authority of the common law of England, and is not operating under the authority of the King's bench, where every judge under the Articles of Confederation, the United States Constitution is forced to uphold, because you was a weak government and you were subject to the government of the crown. Notice the crown was under the provisions of the Provisional Council in 1704. All right, in 1704. Let's validate that before we move forward. Let's go here. We did War versus Kingdom, Berlin versus Harris. Martin versus Lydell. United States Supreme Court. Best believe everything I'm talking about It's not just being spoken about on this platform. These arguments are being raised in the federal court as of today. All right? On your behalf. When I say your behalf, I'm talking about the English subjects. No other subject but English subjects. So if you're not an English subject, when justice is rendered, which it will be rendered, you will have no undertaking of what's been prescribed for all those who've been promised this glorious revolution. All right? I'm just going to read a brief from Martin versus Waddell. Martin versus Waddell. Just a brief. It says, the English possessions in America. You hear that? It didn't say British. It didn't say Dutch. It didn't say Spanish. It didn't say Frankish. You know what I'm saying? Because French and English have some type of connection. If you understand the history of what we call the Middle Ages, all right? The late Middle Ages. I cleared it up in past videos. For all those who haven't watched the last video, I suggest that you go research those to get a better understanding of what I'm reading here in this case today. This is the English possession in America were not claimed by right of conquest. You hear that? But by right of discovery under the discovery doctrine, according to the principles of international law, as then understood by the civilized powers of Europe. All right. The Indian tribes in the New World were regarded as mere temporary occupants of the soil, and the absolute right of property and dominion were held to belong to European nations by which any portion of the country were first discovered. The grants to Duke of York was not lands won by sword, nor whether government and laws he was authorized to establish intended for a conquered people. The country granted by King Charles II to Duke of York was held by the king in his public and regal character, i.e. jure regalia, as the representative of the nation and a trust for them. Discoveries made by the persons acting under the authority of the government were for the benefit of the nation and the crown. According to the principles of the British Constitution, was the proper organ to dispose of public domain. All right. When the revolution took place, the people of each state became themselves sovereign, not English citizens, not federal citizens, not naturalized citizens, but English citizens. Very, very, very important. English citizens became the sovereigns in their character, held the absolute right to all navigational waters and the soils under them for their own common use, subject only to the rights surrendered by the Constitution to the general government. A grant, therefore, made by the authority must be tried and determined by the different principles from those which apply to the grant of the British Crown, where the title is held by a single individual and in trust for the whole nation. You all better understand what I'm saying. All those who claim to have an interest in the state here under the United States and the states, that estate was abandoned a long time ago because all that has been pledged under the Articles, under Confederation, under what we call the Engagement Clause. All right? And everything was held in a public trust as under the days of the king. 16-1-28 New Jersey Revised Statute. A right standing in charge of Great Britain, safe from appeal. An act to incorporate trustees of religious society for property held in corporation place thereof. So I mean, incorporations are holding property that belongs to the religious society, i.e. the Church of England. And the only way the property can return to the Church of England is by that who act upon on behalf as custodian of that property held in public trust, which is on behalf of the king. All right, the king. I'll prove that in United States versus Lee. All right, we're getting to it. So let's move forward. State versus Parson. This is another case by Supreme Court of New Jersey, 1950. This is the Supreme Court of New Jersey, 1950. All right. We're still talking about this 1947 Constitution. The 1844 Constitution was the pattern of the United States Constitution, preceded by the New Jersey's Constitution of 1776. All right, and we understand under that authority that the legislature was powerless to separate the authority that was embedded in the King's bench, and now it's still in the Supreme Court. The Supreme Court has took it upon themselves, as established by Ward versus Keenan, by Chief Judge Vanderbilt, as well as by this letter that I showed you here, that they no longer exercise that prerogative anymore, right? Because they know the king is back. And he's coming back for his property under his prerogatives, which is one of the ways to regain his property, such as writ of mandamus, writ of quo warrantor, writ of circulator, writ of habeas corpus, which I'm doing on behalf of my subjects as a result of the estate that was held in trust for my subjects, i.e. English subjects, not anyone else. All right? The law is not biased. It's not rational to any animate or inanimate object. Right here, let me read it. Give me a second. I'm lightheaded. I had to eat something. Sorry for the munching. I do a lot of meditating, a lot of mental evaluation, a lot of internal reception. I suggest each and every one you do that, because by doing that, it transfers your being into a state of a prerequisite that one has to be in to be able to get the remedy that one seeks. All right. This is all coming out of here. Nothing's written down. All of it is coming from here. The interpretation. You can tell if I just read verbatim and don't interpret what it is that I'm reading, then I know I'm just copying, cutting, and pasting. You know what I'm saying? I'm cutting, copying, and spacing, pasting. Look at a lot of the channels out there. Taj Tariq, Asir Ducateers, Sinetta TV, Canaanite Moors, the Hebrew Israelites. Only thing they do is copy and paste, all right? And draw conclusions to what they copy and paste, but it has no traction on grounds that gives one vitality to be able to, or excitability to be able to move forward. Okay, you need that traction. All right, traction. We can't move forward without understanding where we are, and where we are is based upon the past. All right, which I'm giving you, and I'm giving you concrete sources to establish that traction. You know what I'm saying? That you can stick your foot in and be able to plant yourself fully to get a good start to win this race. All right. It's really about who are going to win this race. This constitutional race. Because everything I'm telling you constitutes the race. There is no substance to the contention that under the Constitution of 1947, as Chief Judge Vanderbilt said, in regards to the Cheat Act, which limits the operation of the statute of limitations, even to the point of divesting an accurate right of defense under this provision. The argument is that the statutes, having lost all force and vitality upon the abrogation of the Constitution of 1844 by the adoption of the Constitution of 1947. So we read that the Constitution of 1844 and 1776 are uniform and pursuant to the common law of England. And they said that the common law Constitution of 1844 was synonymous with the United States Constitution before they created the Constitution of 1947. That was stated in Ward versus Kingdom by Chief Judge Vanderbilt out of his own mouth. Out of his own mouth. All right. Let's go on. It says, again came into full force effect simultaneously by virtue of their wholesale reenactment under paragraph 3 of the new Constitution. And so they must be read together and we can reconcile. So that means the 1844 Constitution and the 1947 Constitution must be read in light, must be read together and reconciled pursuant to their predecessors. All right. And therefore the Cheat Act is not subject in manner to the statute of limitations, but the mere continuance of these statutes by constitutional fiat is not indicative of the purpose to abrogate vested rights to defense principles under the statute of limitations. There is no suggestion of a legislative design by the original enactment to annul the bar of statute of limitations and review in favor of a state, in favor of the state, a debt or a demand that inter-parties had lost in vitality by the operation of the statute. So they are saying that the statute of limitations severed the ability for a person to be able to seek redress. All right, especially so in the case of what we call escheatment, i.e., abandoned property. All right, abandoned property. By the original enactment to annul a bar of the statute of limitation review in favor of the state, a debt, a demand that inter-parties had lost and vitality by the operation of the structure. The Constitution of 1947 does not give the statute a radically different quality and meaning. In modern usage, dealing with escheats signifies the falling of property to the sovereign for want of an owner. And this category embraces not only property which has no other owner, but also property whose owner or whose owners' whereabouts is unknown. Under the common law of England, escheats came to be classified as another branch of the king's ordinary revenue. Originally an incident of tenure, and it's now an incident of sovereignty. For those who are viewing this, see New Jersey Revised Statute 46:3-1, New Jersey Revised Statute 46:3-2. Okay. It lets you know in those statutes, as well as New Jersey Revised Statute 46:3-6. It tells you in those three statutes of New Jersey Revised Statute, which was derived from legislation going back to the common law of England, it tells you in those statutes that the land in which we're being referenced today is allodia, and are to remain in free and common soakage, and that the state of New Jersey or the United States does not have any claim in it. It has been discharged. Look it up, New Jersey Revised Statute 46:3-1, 2, and 6. Blackstone's commentary, we know who Blackstone, William Blackstone, states that it was originally an incident tenure as known and now known an incident of sovereignty. The doctrine of deceit at the earliest common law operative only points out the doctrine of deceit at the earliest common law operative only upon that which was the subject of tenure, since it relates to the reversionary right of the Lord to take, i.e., God, Lord, God, whoever you want to call him, to take for one of a tenant, was eventually extended to include personal property, tangible and intangible. The principle was that the right to take that which belonged to no one was to appertain to the crown, as under the crown's jure regalia, i.e., his prerogatives. His prerogatives. See case law. The crown steps in to take the property because it is vacant. Property described as bona vacatina is taken or assumed by the state. It didn't say the United States, it says the state, because we know that the United States is just an affiliation between the states and the confederacies by way of what they call the joining union under the perpetual union by way of the Articles of Confederation, now called the United States of America of 1789. In closing, in this case law, in personal estates which are allodial by law, New Jersey by statute 46-3-6, as I just stated, the king is last heir when there is no kin. The king is last heir when there is no kindred. So the land could not escheat to the state or the United States because they can only own it in bona vacatina, i.e. abandoned property. And if it remains in bona vacatina, abandoned property, that means someone has to come for it. You can't come for it if you're not the owner of the land. The owner of the land, pursuant to 46-3-1 and 2 and 6, tells you that it was the King of England, person, or body of politics, i.e. that can only happen by way of what we call incorporation. Incorporation is by way of incorporation in the government. That does not mean that you're subject to the government, it's just how you incorporate. Majority of those who incorporated in the government was by a charter granted by the government, i.e. United States. The United States government did not grant us our charter. Our charter was granted by the Magna Carta, which is the origin of where charter actually originated from, which is by the king, which was by way of what we call letter patent. How come y'all don't know this? How come y'all don't know this information? It is a sad day when our answers return for us and you're not up to speed on this information. As above, so below. Let's move forward to another case. New Jersey versus Lake. New York. New Jersey versus New York. Two Confederate states, two Confederate colonies, two colonies or states that were subject to the Articles of Confederation as established by Article 6 of the United States Constitution. All right? Superseded by the Articles of Confederation when they were still Confederate states. All right? You were in 1831. Okay, once again, we're still talking about sovereign immunity. We're talking about sovereign immunity. I just showed you under New Jersey by statute 59, New Jersey by statute 59, 13-3, New Jersey waived their sovereignty and agreed to be tried on the basis of individuals and corporations, all right? And we see here New Jersey and New York, two so-called states previously called colonies in 1831 against each other, right? Against each other in regards to a property issue, all right? In regards to a property issue. Let's read it. Come on, somebody show me some love. A comment, hit me up on Cash App, whatever your donations, $ Clifford Jefferson L. Send it to me, because, it takes finance to uplift the English nation. You can uplift the corporations. You can show lift up a de jure nation. Okay, so show your love. Please show your love. All right. You know, you got those groups I used to be associated with, the More Science of America, I was a part of the AEO, you know, none of them brought the fulfillment that I have now. So they were schools of thought. It's okay to be in a school of thought. It's all right. You know, you were a child, but you can't stay as a child. You have to become an adult. When I was a child, I thought like a child. When I became an adult, I put away childish ways. Childish ways are continuing the way of believing in something without having any concrete proof. That's a child. Okay, hoping in something without any concrete proof. That's a child. That's la la land. That's fantasy. That's mythology. That's mysticism. Okay, do you want to stay under that classification? Because that's what they want you to stay in, that classification. I don't. I'm trying to give you a chance. All right. The syllabus in regard to this case of two colonies against each other for property they don't even own, because all property that's abandoned, they can only be abandoned, and it's abandoned. Why? Because there ain't no English heirs here in New Jersey and New York. So of course, the abandoned property is going to fall under the jurisdiction of the so-called entity, soon to be what they call sovereign. And they know they ain't sovereign because they abandoned their sovereignty. Why? Because they can be sued by torts. All right, but sued under about a tort and being sued under the crown, two different things. All right, because as we can see, is the plaintiff in Bellin versus War versus Keenan. He sued by way of a prerogative writ. He didn't file a tort. He filed a prerogative writ and got justice. All right, even though his justice was short-lived, he got justice. All right. So let's see what New Jersey and New York says in the 1831 case. All right. All present. Congress has passed no act for the special purposes of prescribing the mode of proceedings in suit instituted against the state, or any suit in which the Supreme Court is to exercise the original jurisdiction conferred by the Constitution. It has been settled on great deliberation that this court may exercise its original jurisdiction in suits against a state under the authority conferred by the Constitution and existing acts of Congress. All right. The rules respecting the process, the persons on whom it is to be served, and the time of service is fixed. The course of the court after due service or process has also been described. So that means that New Jersey and New York should be well aware of the due process clause in regard to bringing the claim against entities such as the state of New York. And Congress has set procedures or rules in regard to prescribed methods of due process of law in regard to service and time of service. This has already been done on your behalf in regard to due process of law, in regard to process of service and the time of service as prescribed by Congress to bring the claim against the state against their assumed sovereign immunity that they don't have. And a suit in this court instituted by a state against another state of the union, the service of the process of the court or the governor and the attorney general of the state is 60 days. Okay, so that means that if you're bringing the claim on behalf of the state and federal government, that means that the attorney general on the state or federal level should be bringing the claim, bringing a suit or filing a suit on behalf, and the commission of that suit in regards to process of service and the time of service should be well exhausted within 60 days. All right. If the attorney general is not sending the complaint on behalf well in the time frame of 60 days, as well as the return in lieu of due process law on your behalf, that means that you're not getting due process law. All right, you're not. He can't do it. Why? Because he don't act as parental patriarch on behalf of English subjects, those I'm speaking to. They only can act on behalf of parental patriarch of state subjects. And state subjects due process law comes from what they call the 14th Amendment or the Civil Rights Act, or what we call the states, what they call it, the states EEOC Commission, Equal Opportunity Commission, Equal Employment Opportunity Commission. All right, has nothing to do with government at all. Let's read on. The 17th section of the Judiciary Act of 1789, we're dealing with New Jersey and New York, and they're talking about the Judiciary Act of 1789, pursuant to the 1844 Constitution and the 1776 Constitution, as they said that the 1844 Constitution was modeled after the United States Constitution because the United States Constitution came into act in 1789, March 4th, which gave the authority for all the district court judges and the circuit courts that exist within the federal judiciary, which is nothing more than courts of what they call courts of review. Okay, and as we see here, as stated in New Jersey versus New York, 1831, it states that the seventh rule of this court, which was applicable to this matter, was made on August term 1791. The Chief Justice, in answer to the motion by the Attorney General, informs him in the bar. So that means that any of you are in courtroom right now and you're being represented by a member of the bar, i.e. attorney of the bar, he should be representing you on behalf of the King of England and the King's Bench. Why? Because you're reading it right here. The seventh rule of the court, which was applicable to this matter, not just then in 1789 and 1791 as we're reading, but also in 1831. The Chief Justice, in answer to the motion on the Attorney General, informs him in the bar that this court, as was in every other court in the 13th colony, to consider the practice of the courts of the King's Bench and Chancery of England as affording outline for the practice of the court, and that they will from time to time make such alterations therein as circumstances may render necessary. First condition, Section 7, Section 8. In 1796, the 10th rule was adopted, ordered that the process of subpoena issued out of this country and in any suit in equity should be served on the defendants within 60 days before the return date of the said process. And further, that if the defendants of such service subpoena should not appear and return date contained therein, the complaint shall be at liberty to proceed ex parte, which means that without consent of the defendant, of the party which the complaint was brought forth against. All right, this is the case, the matter, or the condition, or the circumstances that are facing this court right as of this day, 2023, October 20th, because I got 6 cases sitting on the docket that are waiting to be served within the 60-day time frame, but they are not operating under the authority of the King's Bench, so therefore they're in violation of Article 6, and therefore are deemed to be disqualified as a result of this disability, as a result of what they call judicial misconduct. It's a violation of law as a result of the judicial misconduct, which would put them in a position of disability because they can't act under authority to them as granted by law, i.e. the Constitution, Article 3. Right? Because Article 3, judges should be operating under the common law of England, as you just stated, pertaining to the Judiciary Act of 1789. Construing these two rules together, they bring us to the case before the court, to the part of the English practice where the party may proceed toward hearing. There is no necessity for those proceedings here, which are resorted to England to compel an appearance. You hear that? Because it is not referring to English subject. They're referring to New Jersey citizens. They're referring to New York citizens. They're referring to naturalized citizens. They're referring to municipal citizens. They're referring to corporate citizens. All those refer to those who are made citizens by way of an act of statute. All right? Nor would the practice of England be proper in the case before the court. The object of the bill is to quiet a title. It's a bill of peace, i.e. to settle once and for all who owns what. Who owns what? New Jersey don't own it. New York don't own it. The federal government don't own it. New Jersey don't own it, nor any other state in the United States for that matter. Why? Because we just read in Parsons, the Attorney General representing the state of New Jersey versus the Standard Oil Company, which was a company created by the Rockefellers. All right, which started all these de facto monopolies, violation of antitrust law. They said that these monsters, as well as what's that case, Legit versus Lee, I think it's Legit versus Lee, that all these corporations that exist today are nothing more than a Frankenstein monster, a production of Frankenstein, acting without a brain. All right? These are facts. Facts. So as it's just stated, that New York versus New Jersey was the matter before the court, i.e. The district court, I mean the Supreme Court in New Jersey, which was acquired a title, a bill of peace. Any one of those who don't know what a bill of peace is or acquired title, please look that term up. Let's move forward. Let's go to Browns versus State of New York. Real quick. Real brief. New York. We just read New Jersey versus New York. And New Jersey versus New York, it said that the Judiciary Act has set a standard for time of service to parties, the required time of service, which is 60 days, and if the felon to return or give a response to that service and the time of service, then the party may proceed ex parte without the consent of the defendants in regards to a matter brought before Supreme Court in lieu of the proceedings instituted under the authority of the King's Bench, because only the King's Bench can acquire the title when it involves property belonging to the King, i.e. the Crown. Because all property belonging to the Crown is called Crown land, and all Crown land is what we call entail. And entail deals with inheritance, all right, heirs. We know heirs can't get it because they're in street, so it falls to street under the abandonment of the federal and state government, which the only person now can retrieve it is the King, all right, which I'm trying to do on your behalf, but you must be an English subject, all right? It says, in this case, Brown versus New York, in regards to a complaint brought forth by a citizen of New York versus New York, it stated that finding the courts have looked to the common law antecedent of the constitutional provisions to discover whether damages remedies may be implied in regard to bringing a claim against a state in lieu of them not having any sovereign immunity. The New York First Constitution, 1777, recognized and adopted the existing common law of England. Now, if you read Constitution of New York in 1777, they wasn't sure about the common law of England at that time in 1777, but yet we're reading a case law in 1996, y'all. In 1996, Brown versus State of New Jersey is clearly telling you something contradictory what they said in the Convention of 1776 about them being unsure or it being unknown about the effects of the common law of England, going back to the original intent of those who were sitting in those conventions under the authority of the parliamentary convention that was established, that was pattern of Parliament going back to our customary law, going back to time immemorial. This is finally the court have looked at the common law antecedent of the constitutional provisions to discover whether a damage remedy may be implied. New York First Constitution of 1777 recognized and adopted the existing common law of England, and each succeeding constitution has continued that practice. Thus, in some cases, there exists grounds for implying damages remedies based upon pre-existing common law duties and rights. So there you have it. There you have it. New York practices the common law of England, accepts the procedural processes that are established by the King's Bench, have established by the common law of England, have established in New Jersey versus New York, and that's established in, as they stated in Ward versus Keenan, right? Because we know that the legislature was powerless to sever that authority that the King's Bench had and the Supreme Court, and both courts, I might add. All right, so let's move forward. And this will be in closing. Everybody pull that up. United States versus Lee, 106 U.S.1961882. Forgive me. All right, got ready? It's very important because we'll also deal with the supremacy or sovereign immunity of the United States or the states. All right? But we know sovereign immunity is for a sovereign. Once again, sovereign immunity is for a sovereign. We see it in Bellin versus Harris, Ward versus Keenan, Martin versus Waddell. You can see Johnson versus McIntosh. You can see United States versus Washington Art. There's so many cases out there that can make reference to our power and our authority, which have yet to be understood by those who the power lies in. Because it said the power lies in the people. All right? The power lies in the people. It says here, United States versus Lee. The primary holding in regard to this case law as provided by who? Supreme Court. The Supreme Court, everyone. The Supreme Court. The United States Supreme Court and the Supreme Court of New Jersey are uniformly, are synonymous pertaining to the intent of the Constitution of 1844, as we read in Bellin and as we read in Ward versus Keenan. All right, they're synonymous, they're equal, they're parallel, they're twins. This case was decided in 1822. The purpose of the case was to rule on the sovereign immunity of the United States in regards to a claim being brought against the United States as an entity. It says in the primary holding, when an action does not need to involve the United States as a defendant or a necessary party, the principle of sovereign immunity should not be invoked to deny plaintiffs the judicial enforcement of their right. Oh, so it's oxymoron. If the United States is involved, then that means you can't involve them. Why? Because it will put them in a what they call a vulnerable position. All right. You see, also see the case by Jim Marshall. The case by Jim Marshall. Johnson versus McIntosh. Forgot that case by Jim Marshall. But anyhow, it states here, United States versus Lee, that they're saying that as long as the United States are not at issue, you can bring a claim against an agent or officer of the United States without them resulting or relying on the Sovereign Immunity Act. Okay, let's go in on this. Why? Because we know Bellin versus Harris says that the Ward versus Keenan says that the plaintiff, Keenan, in the case against the city of Newark, even though he has assumed that got a remedy in regards to filing a claim against the sovereign immunity that the state claimed to have, the Superior Court and the Appellate Court ruled in his favor until it got to the Supreme Court. All right, but the Supreme Court abandoned the theory of the prerogative writs. Why? Because as we read in the letter, the prerogative writs were invested in the Superior Court. 4 colons, New Jersey Court Rule 4:69-1. So the Supreme Court, to entertain such an argument, will show you that they committed treason. They committed a felony. All right, so they allow you to bring a complaint against an officer of the state, long as if he violates judicial misconduct, which warrants disability, then you can bring a claim. But under the commissions that were established to raise those arguments, but not under a constitutional forum, which was established, because as we see on the Administrative Review of 1887, it says that the administrative agencies, as established by the United States government and the state government, was based upon the intermingling of executive, legislative, and judicial tendencies. All right, far-fetched from the authority that derived from the jure government. All right, as established by the Constitution. All right, which sets the perimeters. Let's move forward. You can go down to I-205. Everyone goes to I-205. It's gonna be good. Y'all gonna like this. Everybody, wait for you to get there. Shout out to all those who got the courage to build this channel. I love you. Once again, if you love your king and the work he's doing for you, please show your love by sending your gifts, your donations to $ Clifford Jefferson L. Okay, I really would appreciate it. Our service is worthy of his hire. Okay, let's get started. I can't wait to go back to review this lecture. In order to decide whether the interference is justified from what is conceded, it is necessary to ascertain, if we can, of what principles the exemption of the United States from a suit by one of its citizens is founded, and what limitations surrounds this exemption. And this, as is in most other cases of like character, it will be found that the doctrine is derived from the laws and practice of our English ancestors. And while it is beyond question that from the time of Edward I until now, so if you're not a member of the plantation crown, then you're not the one being referenced to here in United States versus Lee in regards to being able to bring a complaint against somebody claiming to be sovereign, because those who claim to be sovereign is under the door of what we call prescription of easement. Prescription of easement is somebody claiming to be sovereign without that sovereignty being attested. Look it up. Prescription of easement is known as a right to use property that don't belong to you. It's called a non-possessory right. Okay? You know, Edward I was the son of Henry III. Henry III was the son of Henry II. Henry II was the son of Godfrey, and Godfrey was the fifth count of Anjou, son of Fulk, ruler of Jerusalem. So all those who want to inherit Jerusalem, you better be listening to what I'm telling you. Why? Because according to what they state here, in regards to bringing the claim, when they came to resort to the immunity clause, in which the complaint being brought forth by a private citizen, as said by Chief Judge Vanderbilt, which was denied by a citizen, as Chief Judge Vanderbilt said, which was Keenan, the police officer. He couldn't do it, but a private citizen could do it under the crown, and I'm doing it under the crown, as should be by the crown prerogative. All right, and under the crown prerogative, the United States or the state does not have any immunity, because I proved that they waived it. Why? Because they broke their oath, and their oath, according to the origin of oath, under the Kingdom of England, was to King Edgar the Peaceful, which I'm the reincarnation of. So it says, in order to decide whether the interference is justified from what is conceded, it is necessary to ascertain if we can, on one principle, the exemption of the United States from a suit by one of its citizens is founded, and what limitations surround this exemption. In this, as in most other cases of like character, it will be found that the doctrine is derived from the laws and practice of each of our English ancestors. And while it is beyond question that from the time of Edward I until now, the King of England was not suable in the courts of the country, except where his consent had been given on a petition of right, i.e., that's prerogative. And it is a matter of great uncertainty whether prior to that time he was not suable in his own court and his kingly character as a person were, as other persons were. We have the authority of Chief Baron Commons, that such was the law in a bracket in Lord Holt, that the king never was suable of common right. It is certain, however, that after the establishment of the petition of right, about that time as the appropriate manner of seeking relief, where the ascertainment of the party's right required a suit against the king, no attempt had been made to sue the king in any court except as to allow on such petition. It is believed that this petition of right, as it had been practiced and observed in the administration of the Justice of England, has been inefficient in securing the rights of suitors against the crown in all cases appropriate to judicial proceedings as that which the law afforded in legal controversies between the subjects of the king among themselves. So they're letting you know that the king only allowed suits to come forth in regards to those involving those against each other, because a king or the crown or the monarch cannot be sued in his own court because he's the sovereign. Okay, he's the sovereign. Now we see the president acting as the sovereign, but when you see the sovereign, i.e. the president, can be brought on torch. All right, when he violates his conduct. All right, when he acts outside his judiciary capacity. All right, but in this case, the origin of the sovereign immunity gets its origin from the sovereign immunity that was established back in the time of the crown, going back to Edward I. And we know under sovereign immunity of the crown, the king can do no wrong. All right. All right. The king can do no wrong. And under Article 6 of the Constitution, since there's no religious test in regards to holding the office or public trust, that means that all I have to do is file a complaint on behalf of the king as a private citizen by way of the king's prerogative, and the prerogatives of a private citizen in lieu of the crown will automatically be effectuated by that power that is still in the king. And the only person that has done that thus far is me. All right. If the mode of proceedings to enforce it be formal and ceremonious, it is nevertheless a practical and an efficient remedy for the invasion by the sovereign power of an individual right. There is in this country, however, no such thing as the petition of right, as there is no such thing as a kingly head to the nation or to any other state which composed it. Did you hear that? They claim there ain't no sovereign. I'm showing you there is a sovereign because the Supreme Court says there is. All right. It's just the practice that the United States has undertaken pursuant to their understanding of what they call sovereign immunity and claims against the sovereign immunity of the state in regards to their citizens. All right, which must be looked at in different, which must be looked at at different parameters because they're on the opposite end of each other. They're invested in no officer or body the authority to consent to that shall be sued except in the lawmaking power, which may give such consent on the terms it may choose to impose. Did you hear that? There is vested in no officer or body the authority to consent that the state shall be sued except in the lawmaking power, which may give such consent on the term it may choose to impose, i.e. the statute, as we see in New Jersey by statute 59:13-1. All right. It has authorized suits to be brought against the United States, but has limited such suits to those arising on contract with a few important exceptions. What were the reasons which forbid that the king should be sued in his own court? And how do these reasons apply to the political body, corporate, which we call the United States of America. Once again, what were the reasons which forbid the king should be sued in his own court? And how does this reason apply to the political body corporate, you hear that, which we call the United States of America? Question mark. As regards to the king, one reason given by old judges was the absurdity of the king sending a writ to himself to command the king to appear in the court, in the king's court. You hear that? Once again, as regards, an example they gave, as regards to the king was one reason given by the old judges, was the absurdity of the king sending a writ to himself to command the king to appear to the king's court. No such reason exists in our government, as processes ones in the name of the president. It may be served on the attorney general, as was done in the case in Chisholm versus Georgia. So that's letting you know that the attorney general, under the guise of the president, as the chief officer and head, chief, what's called head, what they call the head person in charge, he was the only authority in regards to bringing remedy in regards to a prerogative writ on behalf of some an injury that was caused by an agent or officer or somebody acting in their official capacity. All right, but there's a difference between that here in the United States and that in the Kingdom of England, as just stated. All right, which is yet to be determined, which we're going to be determined now. All right, it says, nor can it be said that the dignity of a government is disgraded by appearing as a defendant in the course of its own creation, because it is constantly appearing as a party in such courts and submitting its right as against the citizens to their judgment. Go a little further. Right here. On the other hand, while acceding to the general proposition that it is no court, that in no court can the United States be sued directly by original process as a defendant, there is an abundant evidence in the decisions of this court that the doctrine, if not absolutely limited to cases in which the United States are made defendants by name, is not permitted to interfere with the judicial enforcement of the established right of plaintiffs when the United States is not a defendant or necessary party of the suit. But little weight can be given to the decision of the English courts on this branch of the subject for two reasons. All right. So there's a difference between the interpretation of sovereignty in the United States and sovereign immunity in the United States and sovereign immunity in English, in the English courts. All right. But little weight can be given to the decision of the English court on this branch of the subject for two reasons. One, in all cases where the title to property came into controversy between the crown and a subject, whether held in right of the person who was king or as a representative of the nation, the petition of right presented a judicial remedy, a remedy which this court, on full examination in a case which required it, held to be practical and efficient. There has been, therefore, no necessity for suing the officer or servant of the king who held possession of such property when the issue could be made with the king himself as a defendant. You hear that? So all we got to do is the king bringing in the complaint as a defendant by way of removal in lieu of federal questioning, or as a defendant in a complaint against an agent officer of a state in lieu of warrant for removal in lieu of federal questioning, or federal, let me say that right. A defendant can present a prerogative writ in lieu of removal if he's not getting due process of law in the state court in regards to the authority of a constitutional question which the federal court were put in place to deal with. All right. So we understand that there's a difference between being heard in regards to federal question and the district court, or removal because of diversity issue in the federal question, because we know cases can be moved because of the diversity of jurisdiction in regards to citizen against a citizen. And we know there's different types of citizens in states and different types of citizens in federal states. All right, you must understand that. Two, another reason of much greater weight is found in the vast differences in the essential character of the two governments as regards to the sources and the depositories of the power. Notwithstanding the progress which has been made since the days of the Stuarts and the stripping of the crown of its power and prerogatives, it remains true today that the monarch is looked upon with too much reverence to be subject to the demands of the laws as ordinary persons are. And the king-loving nation will be shocked at the spectacle of their queens being turned out of her pleasures garden by a writ of ejectment against the gardener. The crown remains the fountain of honor, and the surrounding which gives dignity and mastery to its possessor. Possessors are cherished and enforced all the more strictly because of the loss of real power in the government. It is not to be expected, therefore, that the courts will permit their process to disturb the possession of crown by acting on its officers or agents. Okay. In closing, under our system, the people who are their called subjects are the sovereign. Once again, the sovereign. Their rights, whether collective or individual, are not bound to give way to a sentiment on loyalty to the person of the monarch. The citizen here knows no person, however near to those in power, of however powerful himself, to whom he need yield the rights which the law secures to him when it is well administered. When he in one of the courts of competent jurisdiction has established his right of property, there is no reason why differences to any person, natural or artificial, not even the United States, should prevent him from using the means which law gives him for the protection and enforcement of that right. Another class of cases in English courts in which attempts have been made to subject the public ships and other property of foreign and independent nations founded within English territories to their jurisdiction is also inapplicable to this case. For both by the English court and ours, it has been uniformly held that these were questions the decisions of which, as they might involve war or peace, must be primarily dealt with by those departments of the government which had the power to adjust them by negotiation or to enforce the right of the citizens by war. In such cases, the judicial department of this government follows the action of the political branch and will not embarrass the latter for assuming an antagonistic jurisdiction. So as you can see, under the authority of the sovereignty that the United States assume that they have, they are not willing to give it up at the under the presentment of a claim brought forth by one of their citizens, i.e. a state citizen or a United States citizen, because as we see in War versus Keenan, the prerogative writ was left for the remedy left for those who were subjects of the crown, whether in an individual capacity or a group capacity, i.e. Class action, all right? So we know that in order for us to be able to reclaim our rightful estates as heirs under the sovereign immunity created by the crown, under the public trust by the monarch who acts as corporation sole, you must understand what's being said to you today. And I end with this. Let's go. This is closing out for every one of you. Let them know that case law, which we present today in regards to the United States and the states acting as sovereigns, is a lie. It's a lie. And the only way it continues to remain a lie is the true sovereigns don't wake up, all right? Because this is the way your estate is being cheated from you, all right? as you're assuming to be state citizens and United States citizens. And state citizens and naturalized citizens under the Naturalization Act has nothing to do with you're being part of a country or a nation that has some type of political structure set in place for you to protect your rights in lieu of what we call due process of law, to bring claims against infringements upon those rights through due process of law, as established by the Articles of Confederation, as well as established by the Magna Carta, as well as established by the remedies that were in case law that were provided for those who understand what's being said to them today. So in closing, prescription is an international law. It's sovereignty transfer of a territory by the open encroachment by new sovereigns upon the territory for a prolonged period of time, acting as a sovereign without protest or other contest by the original sovereign. It is analogous to the common law doctrine of easement by prescription by private real estate. So once again, we know that the United States is not the sovereign because the United States within itself can only act on behalf of what they call the authority that was given them by the Crown, as prescribed by Bellin versus Harris, War versus Keenan, state represented by Attorney General versus the Standard Oil Company, Johnson versus McIntosh, Martin versus Waddell, Brown versus State, New Jersey versus New York, as well as any other reference that I used in this case, in this lecture today, all right? So I love you all, and I really hope that you really take what's being said to you seriously. I don't think there's any other platform out there putting it down like I'm putting it down. Like I said, everything that is presented to you is validated factually, arguably has presented factually, and arguably tailored for you to raise a sound argument in any court of law in regards to your right as an English heir. Okay? But if you're unwilling to do that, then it's my obligation to do so. All right? But you will be judged accordingly as a result of your acquiescence, as we know is treason for you not pledge or your allegiance or your oath of allegiance to your nation for who you say you come from. And with that, I'll say peace.